everybody ready? Oh. Court rise.
I'm sorry, Mr. Milford, when you're longing to get started, I've just got one question for Mr. Bunting, arising out of our perusal of SC. In the discussion, which obviously is threaded through the whole thing, of the way in which to approach suspect grounds cases, yes. The language is always used suspect ground, the grounds of one of the suspect categories, or a decision taken on the basis of one of the suspect categories. And I haven't had a chance to do a proper historical review, but just it's pretty clear that that terminology started in cases where you had effectively direct discrimination on the grounds that typically of sex. I think it probably started the pension cases, but anyway, there are lots of social security benefits which directly differentiate between men and women. Now, in North Fliminos at the moment, suppose that this is an indirect discrimination case. Certainly using ordinary domestic terminology, we wouldn't talk about such a decision being taken on the grounds of sex. The discrimination which occurs here on grounds of motherhood. This is a case of indirect discrimination, but where the motherhood is the characteristic of the people who are disproportionately affected by it. The language of grounds is not really appropriate. Are you aware of any consideration in the Strasbourg case law of whether what I might call the suspect grounds factor applies in the same way to indirect discrimination as to direct discrimination? Sorry, it took me a long time to come to the point, but I hope you now understand.
Yes, I have the point.
What the issue is.
I don't have an immediate answer to it, but
with this careful team of juniors behind you, even though one of them isn't wearing a wig.
I've been trying to signal to him, but he wasn't.
With this impressive team of juniors behind you, even more impressive now, they might be able to find the answer. My strong hunch is that there isn't, and the reason there isn't is that only when pressed do they really even tend to talk about direct and indirect. It's not part of Article 14 itself, it's only there in the case law.
Yes.
But the most you might find is cases of it being referred to in cases which are factually clearly indirect rather than direct discrimination cases. So
yes.
If someone could do that exercise, I'd be helped.
Yes. I think.
Otherwise, one thing we might want to think about adding to the jurisprudence, we might or might not, but we might want to think about adding something about whether a suspect ground is quite such a weighty consideration where we're only dealing with indirect discrimination.
Yes. Thank you.
Thank you, my lord. So
Don't feel obliged to jump on that bandwagon, Mr. Milford. It may be one with no wheels, but
I will come to it in due course, if I may, my lord. So I'm going to deal with the 3 grounds of appeal in turn, but before I do that, I wanted to make a preliminary point that really arose out of the discussion this morning about the various ways in which the scheme could have been tweaked, which is context. The lockdown was on the 16th of March. The design of the scheme, in its essentials, took place within days. It was there by roughly the 22nd of March. The direction was made on the 30th of April, and payments in the sum of billions of pounds were made starting from late May. So simplicity, ease of design were absolutely critical. And that's not a matter of administrative convenience, simply, but just to allow the scheme to function at all and to get payments to the people who needed it. And before diving into the 3 grounds, I just wanted to pull up a bit of the witness evidence that we didn't look at this morning, which is Mr. Hackon's statement.
So we really are starting with justification, I know, Mr. Milford.
We're starting with context,
That's where you.
my lord.
That's your
Yes.
Okay.
Yeah.
Supplemental.
Supplemental, page 216. This is part of a section of Mr. Hackon's statement where he deals with the design of SEIS and the system. And the particular paragraphs that I wanted to draw to the court's attention are 14 to 19, because they make a series of interrelated points. So at 14, one starts off with the first point that HMRC didn't have a system with the functionality of SEIS. It was a unique ask. It had to be designed from scratch. It was bespoke. And it explains over 200 IT staff working on it. That's paragraph 14. Paragraph 15, in order to develop it as quickly as possible, we made extensive use of existing technology and design patterns. So what might be thought to be an obvious point, if you're going to design a system from scratch, you've got to use what you've already got as far as possible. Paragraph 16 explains that this was still an extremely complicated exercise. So about 2/3 down there, this work included integrating data from 13 different systems, 75 scheduled data deliveries encompassing, etc., 15,000 lines of code. Paragraph 17, lots of other stuff was being worked on at the same time, as I need hardly say. Paragraph 18, at the same time, a lot of HMRC staff were working from home. And paragraph 19 is really the bull point that pulls those threads together. In the light of all the above, certain fundamental principles underlay the design of SEIS. SEIS had to be put in place at great speed for the reasons I've set out, had to be reliable, had to be accurate, calculating grants on the basis of certain and verifiable underlying data which was already in HMRC's possession, had to have measures built in that would protect to the extent possible from errors and fraud, and had to be automated as far as possible, given the need for speed, reliability and accuracy, and also had to be simple. So I do say, just as a matter of context, that those points cannot be overemphasised. Let me turn to ground 1, indirect discrimination. In my submission, the judge's conclusion here was right. There was no indirect discrimination because recent mothers were not placed at any relative disadvantage by the application of SEIS. Now, my learned friend and I are agreed that the relevant definition of indirect discrimination is paragraph 175 of DH, and I wondered if we could turn that up. It's tab.
we could, but haven't we already seen it as quoted fully in SC? But you have a reason.
My lord, I have a
I'll
reason
trust
because I wanted to have a look at various other bits of the judgment.
Yep.
It's page 1169. Now,
Sorry, I just didn't quite write down your fundamental proposition. No indirect discrimination because recent mothers were not placed at any relative disadvantage
because of the application of SEIS.
because of the application of SEIS rather than because of the application of the...
Well, the ATP calculation is...
So you're happy
Yes.
with it putting it
I'm
that
happy
way?
with that.
Yes, there's no, I wonder why you said size, but you mean the 80.
I mean the ATP.
And, sorry, page number again, 11 something?
1169, my lord. We say that there are three important points about that definition, paragraph 175, towards the bottom of the paragraph, that the claimants overlook. The first is that it requires disadvantage relative to others.
I'm so sorry, I must have got the wrong page. Which page did you say?
1169, my lord. That's the...
It's my fault, I was looking at 1069. Okay. Yep. Carry on.
Yeah. The first is that the definition requires disadvantage relative to others. The group of which the claimant forms part must be disproportionately impacted, or to use the usual phrase, there must be differential impact. So it's a comparative exercise. The second...
And which paragraph were you relying on particularly for that? 175?
It's the definition at 175, my lord. The court has also accepted a general policy or measure that has disproportionately prejudicial effects, and that's where we get
Yes, you're
relative
spelling out
disadvantage
what
from.
word disproportionate means. It must be disproportionate. It must be more for one group than for another.
Indeed.
Yeah.
And that relative disadvantage must be caused by the PCP. That's the second point.
Or the measure, as we call it in this context.
Indeed.
Yeah.
And the third point is that this definition mirrors the definition of indirect discrimination under EU law, for instance, the Race Discrimination Directive and Burden of Proof Directive, and is clearly intended to do so.
Probably your last point doesn't... Does that matter very much, but it's clearly intended to do so? It's not clear. Obviously, we know Strasbourg looks at Luxembourg and Luxembourg looks at Strasbourg, but that's not quite the same thing as saying they're deliberately intending to...
It's not quite the same, my lord, but if one looks, for example, at paragraph 184, one can see the court there aligning the definition of indirect discrimination that it has applied with that under the Race Discrimination Directive and the Burden of Proof Directive.
So just repeat your third proposition again. I want to get it absolutely right.
The definition of indirect discrimination at paragraph 175 of the judgment reflects the definition applied in EU law and is intended to do so. And I make that point.
Sorry, 184, what is ECRI?
So
It says see para 50 above, so I suppose I can find out by looking at para 50 above. Get it there. Oh.
Sorry, I'm forgetting my acronyms. 59.
Well, sorry, I'm sure it doesn't matter, but
European Commission Against Racism and Intolerance, immediately above
Yeah.
paragraph 69 on page 1131.
Thank you, my lord.
thank you. Yes, okay.
I just make that point.
What is
because
that? What is the European Commission on Racism and Intolerance? Is it part of the European? Is it
Yes.
a part of the EU?
No, it's part of the Council of Europe.
Part of the Council of
Right,
Europe.
it should-
Okay.
Yes.
Yeah, but what I mean, in a sense, I was giving it whatever, straining it a gnat. It's quite clear that, broadly speaking, the Strasbourg case law borrows from equivalent case law.
Indeed. And that's really, I think, all I need to say about it, because obviously we rely upon case law that considers the EU-derived definition of indirect discrimination, in particular Barry. And in my submission, we're right to do so.
Yeah.
And Barry is, in fact, the most important case for these purposes, because we say, for all practical purposes, it is on all fours with the present case. So let me dive into Barry, which is tab 5 of the authorities. Obviously, my proposition is not that it's binding, since it's EU rather than ECHR, but I do say it is in the highest degree persuasive. And perhaps just to set the scene, it's worth seeing what the factual context for the claim in Barry was, which one gets from page 33 in the speech of Lord Nicola. In other words, Midland Bank sought to retain female employees after they've had children. This is 1470D. Take steps to facilitate their return to full-time work, but assist them to work for a reduced number of hours as key-time workers if that's their wish. So it not only allowed them, but positively encouraged them to work part-time rather than full-time. And Mrs. Barry took advantage of that, but then, of course, had her voluntary severance calculated on the basis of a part-time salary, because that was her final salary, and claimed that that was indirect sex discrimination. So it was a very similar issue to what one has arising here. You've got a payment which is said to have been smaller than it would otherwise have been because of a maternity-related reduction in hours, and the claim was that a different method of calculation should have been adopted in order to avoid discrimination.
Sorry, will you just say that again? I just want to get it down accurately. The situation is that you've got a payment different from...
Smaller than it would otherwise have been because of a maternity-related reduction in hours.
Okay.
And the claim was...
Wait 1 second.
I'm so sorry, Murray.
Yeah.
And the claim was that a different method of calculation should have been adopted in order to avoid indirect discrimination. And as my lords and my lady have seen, the House of Lords concluded by a 4-1 majority that there was no prima facie indirect discrimination requiring justification in the first place. And the nub of the reasoning is contained in my submission in Lord Hoffman's speech, which starts at 1478 of the...
So you're not sticking to Lord Nichols, despite the steer from the Lord.
Oh,
Well,
Lord Nicholas dissented on this.
Lord Nichols dissented on this issue, albeit not in the result.
Yes. No, I was just... I won't explain my observation, which I agree with.
I'm teasing my Lord, not you.
Sometimes you can look at the dissenting judgment in order to see what the real point being made by the majority is. I won't go on defending myself. Right.
So if one starts off at 1478 in the speech of Lord Hoffman, between G to H, he makes the point that if there's no discrimination between the sexes, there can be no complaint. that a different method of calculation would have led to a different outcome. The way he puts it is, if both part-time and full-time employees have pay calculated in the same way, then it's not open to part-time employees to complain that they'd have done better with a different method.
And it is irrelevant that a disproportionate number of women are part-time workers. Yeah.
On the other hand, if the method of calculation means that part-timers are treated differently from full-timers, that will prima facie be discriminatory on the basis that many more part-time workers are women. Then, starting from 1479D, he addresses the CJU's case law. And in essence, that's done by giving cases on both sides of the line. So he talks about Bilka Kaufhaus and Kowalska, which are on one side of the line. Those are barrier cases where entitlement to a benefit is based upon full-time rather than part-time working. And then on the other side of the line, as one sees from the top of 1480, is Stadt Lengerich against Helwig. And that was a case where pay was calculated on the basis that you got extra pay or better hourly rate for the hours that you worked over 38.5. And a claim was brought by a part-time worker who said, well, it's a lot more difficult for me to reach 38.5 hours. And the court's conclusion was, this wasn't discrimination. A uniform criterion is applied to everyone. And the real complaint here is that a different scheme would have been more advantageous to part-time workers, not that the existing one was discriminatory. So that's the distinction drawn in the EU case law, which Lord Hoffman is applying. And he does that starting from 1480F. If one applies these principles, the answer to the present case would appear to me to be plain. Redundancy payment is clearly pay. Next question is whether the method of payment has a discriminatory effect. It has two criteria. One is final salary, the other is prior years of service. Neither has any effect which discriminates between full-time and part-time workers. The final salary of all workers is taken into account, whether they're working full-time or part-time. Of course, the part-time workers are earning less, but that's because they're working less. There's no infringement of the principle of equal pay for equal work. So in other words, the disadvantage, if disadvantage there be, is not caused by the criteria themselves, but simply by the fact that Mrs. Barry is doing less work.
Well, are you saying that this case is analogous to that?
I am.
Mm-hmm.
And that
then what's your I was sure that my lord was doing the follow-up.
No, you go.
What's your answer to Mr. Bunting's point that they are concerned with completely different types of steam? The Barry steam, the intention is to compensate you for the loss of what you would have earned. Actually, stand back a moment. Severance steams actually are slightly hybrid in their. There's an element of compensation for past service. There's an element also of reward for past service, saying thank you to someone who's been with you a long time. There's also an element of compensation you for what you've might have earned if you stayed. But either way, focusing on the hours you actually worked in the reference period is entirely appropriate and relevant, because those are the hours you in fact worked, and the earnings you in fact made. Those are the earnings that you would have made if there's an element of compensating you for a notice period, say. This is different because the only point is to compensate you for what you would have earned in the future for which, in most cases, a perfectly sensible proxy is what you earned over an equivalent period in the past, but not in a case where there's a gender-related reason why your past earnings are untypical. It's the element of untypicalness or unrepresentativeness which is present in this case, but not in that.
Well, I think there's sort of 3 points that I need to make in response to that, my lord. The first is that the purpose of this scheme, precisely as with the purpose of a redundancy payment, the basic purpose is cushioning. I mean, in the case of a redundancy payment, it's because you've lost your job. Here, it's the adverse effects of coronavirus.
Support.
But
Support.
support.
It's in the title.
Yes, indeed. The second is, and I'll deal with this again when it comes to justification, because it's also relevant to justification, that the purpose of this scheme is to make a payment based upon how an individual's business has been adversely affected by coronavirus. And that involves establishing a baseline, which is how was the business doing before coronavirus? And that baseline is what ATP does. So, for instance, for the recent mother who says, well, I was earning less because I was off on what I might call loosely maternity leave, albeit that term is not meaningful in the context of self-employment. I was taking time off,
Yeah.
as indeed...
Well, sorry to interrupt your flow, but I thought isn't it called maternity leave? What a mother gets, a self-employed mother gets if she says to Social Security, "I'm not going to work."
Maternity allowance.
Maternity allowance. I see. Okay. Sorry.
I noticed your tense, your use of tense in number 2. Purpose of the scheme is to make a payment on the basis of how the individual's business had been adversely affected by coronavirus. Shouldn't it be how the individual's business would have been adversely affected, or maybe that's
Or
will be.
It's
Will be
perhaps
as
just
is
helpful
being.
to turn up perhaps we should turn up the coronavirus direction itself.
Well, we will in a minute, but I'm not sure we need to look at it to meet my lord's point. I mean, it must be the case that the purpose is to reflect the fact that because of lockdown, your business will be less profitable.
Yes.
So it's bound to be forward-looking.
Yes. Yes.
And that's why, if you're looking at the past, you're only looking at the past as the best way of predicting what the position will be in the future. Or a way, the most convenient
Yes.
way anyway.
Yes.
And isn't that a fundamental difference? Because if, for particular gender-related reasons, it will not be an appropriate way of predicting what you would have earned but for coronavirus, then you shouldn't be using it.
Well, no, my lord, it will always be the best and indeed only way of predicting what a person would have earned but for coronavirus is to say, what did they actually earn over an appropriate reference period? And that's exactly what the ATP calculation does.
No, well, I think that's slightly overstating it. You can work out other way, but even if you're right that it's the only way,
only practicable ways.
yes, but it may need adjustment if you can show that in the previous period, in the measurement period or part of it, earnings were untypically or unrepresentatively depressed.
Well, my lord, I think the answer I have to give, my lord, is that a 3-year period for ATP has deliberately been chosen to smooth out differences, to smooth out unrepresentative periods.
But as we've seen in
And-
the case of the second appellant, in 2 of those 3 years, she had a child.
Indeed, my lady, but how else is one going to calculate?
Well, that's
Our
a different
business-
point. That might be highly relevant to justification. But we're simply asking at the moment whether the choice of this measure disproportionately impacts women, or new mothers, if you prefer to make it more accurate or more precise, because new mothers will mostly have depressed earnings compared with what their earnings would otherwise have been, and would therefore have been post-lockdown.
New mothers may, well, I mean, that's the analogy with Barry, my lord. New mothers may have worked less than they otherwise would have done, and therefore they will have earned less, just as Mrs. Barry worked fewer hours, she was part-time. But it is not discrimination to apply a common method of calculation to all persons, irrespective of the number of hours they work. And the reasons why a business may perform differently over any particular period, in this case a 3-year ATP period, are absolutely multifarious. I mean, it will depend upon the type of business, it will depend upon all the various factors why the profits of a business may be lower or higher. And one of those factors will be likely to be the amount of time a person spends in the business. But there is no absolute metric where one can say that person X is in a class that has been disadvantaged by that method of calculation and person Y is not.
Well, that may be so about an individual, but I'm not sure it is, but of a group, you don't need an absolute metric. You say there are all these vicissitudes in the past, and indeed maybe in the future. Maybe that in the period when they lose money because of coronavirus, actually they might have had to be looking after an ill relative anyway, or they might have become pregnant. So you're right that it's all very lumpy and approximate, and the best you can do is try and smooth it out. But is that an excuse for not adjusting, assuming you can, for a factor peculiar to new mothers occurring in your measurement period?
Well, I don't accept that in the context of the purpose of this scheme, the fact that a new mother may work fewer hours is a factor that is unique to new mothers. In the context of this scheme, there is no relevant distinction, in my submission, to be drawn between a new mother who doesn't work for 4 months or a person who doesn't work for 4 months because they're ill, or a person who reduces their hours to look after an elderly relative as opposed to reducing their hours to look after a child.
But that cuts both ways. You might well get an Article 14 claim by carers.
Well, it proves...
Or you might get an Article 14 claim by people who are long-term sick.
It perhaps proves too much, my lord, because if this sort of common method of calculation were to be prima facie indirectly discriminatory in any particular case, then actually one can conceive no possible end to the circumstances in which indirect discrimination might have been claimed. So,
That's the
Mr.
Article
Bunting,
14 for you.
well, Mr. Bunting says to me, well, he said this morning, look at the fact that self-employed women generally earn less than self-employed men. In that case, if Mr. Bunting is right on prima facie discrimination, why
No, that wouldn't follow, because that factor would continue in the coronavirus, in the lockdown period, as well as before. That is statistically a permanent characteristic. The whole strength of Mr. Bunting's case is that this is something which occurs, a loss which is suffered disproportionately by women or by new mothers in a short period, but precisely in a way that might affect the representativeness of the period you've chosen.
Well, my lord, I'm not sure that's right, because for a number of reasons. First of all, because there's so many different ways in which a self-employed person can take absence or not from their business. I mean, they'll either sort of reduce their hours or take a particular amount of time off, or whatever it may be. So it's not an absolute, but rather a slightly.
But it will be absolute if they're claiming maternity allowance, won't it? Because assuming they obey the rules, they actually have to promise not to work during that period. Have I not picked that up correctly?
For maternity allowance, that is right, my lord. But that would only be, I mean, that assumes that you're talking about a class of a more limited class of people, or a differently defined class.
That was actually the class, I think, although Mr. Bunting slightly, with encouragement, shifted his ground this morning. I think the judge said that the class you were all talking about below was women claiming maternity allowance, wasn't it? Or have I got that wrong?
I don't think so, my lord.
Let's have a look at what I was thinking. Well, it's not quite accurate. It's para 53 I had in mind. Tell me when you're...
Yes. Who have been
no
on
dispute
maternity
women
leave.
have been on maternity leave, which I'm afraid I assumed, I'm not having all the jargon at my fingertips, was the same as who were claiming maternity allowance, but you say not.
No, not. Maternity leave, as we understood it, was just used as a broad term for
Not
taking
working
time
because
off
they're
and
new
not
mothers.
working,
Or working less.
or working less.
Because the nature of your business, it could easily be the case that you worked 8 hours. When you have a young baby, you do go on working, but you can only work 4 hours.
Yes.
And that would be a very common pattern.
Yeah.
But you wouldn't be allowed to do that if you were taking maternity allowance. You'd be on your honour not to work at all. Goodness knows how that's policed. Is that, I've got that right,
Yes.
haven't I? Yes.
And
So your point was that there are many reasons why someone might work less.
yes,
Motherhood is
yes,
only one.
Yes, and indeed, the amount that someone has been works over a period, whether it's a period of maternity leave or any other period, is also going to affect how their business performs after that period, if you're self-employed.
But just taking an obvious point, if you have one group who are the mothers and another group which are carers, and in this case we are saying there is indirect discrimination against the mothers. The fact that no one has taken the point in respect of the carers, well, it does come to two wrongs don't make a right, doesn't it?
My lady, if there were indirect discrimination against mothers, that would certainly be right. But I say that the fact that one can think of any number of reasons why a person might be working less in their business, or indeed why the business might be less successful, or etc., etc., the fact that there is no clear line to be drawn is a reason why, in this case, in fact, on a proper analysis, there is no relative disadvantage caused by the ATP calculation itself. There's no metric for measuring such disadvantage.
That can't be right, can it? There must be a metric. Take 100,000 people. Of whom 10,000 are new mothers, and assume, to make it easy, all the new mothers take maternity allowance for the maximum period for which it's payable. Someone will tell me what that is.
9 months.
9 months.
9 months. which you can take, you can take early and you can take in your late pregnancy, or you can split it as you like between pre and post birth. Is that roughly right?
Up to a point.
Up to a point. Okay, so getting back on track, they take their 9 months, and they do not work during that period because they promise not to. It's a condition of the allowance that they don't. Whatever their relative position to the other 90,000 before that happened, it's bound to be less after that happened. May not be pound for pound less, depending on the nature of the business. They may continue to make profits even while not working for a bit, but ultimately it'll kick in.
Well, my lord, I think it comes down to an essential problem with, in my submission, how one applies indirect discrimination concepts to a claim such as this, because it's easy enough to see how a new mother can say, if I had not taken that time off, I would be doing better.
And you don't mean easy enough to see, but it might not be true. You accept that in one sense it is true.
Indeed, my lord, I do. What is a great deal more difficult to see is how you establish differential treatment as between others, relative disadvantage, where you have no barrier, no gateway, no rule that applies to some but not others, of the sort that
But
one
in
has
ordinary
Blackburn,
indirect
SC.
discrimination, the idea that it was all based on a barrier is ancient history. Under the 1975, that was the concept. But now, under the influence of European case law, we've got much fuzzier about it. Enderby type discrimination and so on. It's enough just to show that because of a protected characteristic, you are in fact at a disadvantage, even though it's not because of something you can define as a barrier in the rules. No?
Well, my lord, there's a reason why there is no case, as far as I'm aware, where the level of a benefit in itself and where that level is variable, or indeed the same as in the case of something like statutory sick pay, has been found to be discriminatory. And all the cases that we've been looking at and that Mr. Bunting says are analogical, so for instance Blackburn, are cases where a rule has meant that some people fall on one side of it and others fall on the other.
Well, is there an example
that's
of a
all
benefit payable using a formula as crude as this? Crude's my word. A formula like this.
Well, I say, my lord, that Barry is exactly this sort of example.
Yeah.
And there's a
Give us
reason
your answer
why.
to why.
And Stadt-Lengerich as well, sort of saying that you will pay an enhanced rate to people who work more than 38.5 hours. I mean, one can easily...
But you do appreciate Mr. Bunting accepts all that, but says there is a distinction, which is in this case, the past is being used as a measure for a future loss. And if it can be shown to be a less accurate measure, over and above the inherent inaccuracy, which everyone accepts, but for a gender-related reason, then that is discriminatory. You may still be able to justify it.
I think my answer to that, my lord, is that really that's a distinction without a difference. I mean, that relies upon purpose, but logically one would think that purpose comes in when you are looking at justification. And the question that one is really looking at here is simply, has there been relative disadvantage caused by the PCP that you're looking at, in this case the ATP calculation? And we say answer no. To the extent that there has been any, it's caused by the fact that someone worked fewer hours.
Well, the ATP calculation leads to someone like Mr. Chamberlain receiving less money than she would have received had you used a different formula or a different method.
Or had she not been a new mother.
Or had she not been a new mother. No,
Just as in Barry, the use of that calculation meant that Mrs. Barry got less because she was working part-time rather than full-time. So, my lord, I don't want
I
to...
said Barry was a difficult case.
I don't want to labour this because I'm conscious that I've got quite a lot of ground.
Yes, no. You
cover.
put it, I think, as clearly as it can be put. Can I just note, I didn't ultimately think this will matter, but I think it's important for accuracy that we do take a view on all this, that the actual declaration sought, if we look at the core bundle at page 155, in the original JR claim, was a declaration that SEIS unlawfully discriminates against women who have taken a period of absence from work for reasons relating to pregnancy or maternity. So it's not, as you rightly said, pinned on taking maternity allowance. Though it might be jolly close to, is if by a period of absence they really mean haven't worked at all, realistically that probably means taking maternity allowances. Why wouldn't you?
That might...
The interesting case is the mother who deliberately doesn't take maternity allowances. I can't afford, it's in the interest of my business, I need to go on working a bit, but I will work less. So she's disentitled to maternity allowance, but is still suffering a loss. Whether you call that a period of absence from work, literally it isn't. But these have been slightly glossed over. Maybe a point in your favour by the claimants as to exactly who they're saying, who they're claiming, how they're defining their class.
It is a point in your favour, isn't it? Because it's an example of how there's, your point earlier, there are many reasons. And many reasons, many categories of, or types of people like Mrs. Chamberlain, or quite like Mrs. Chamberlain.
And indeed also the question of new fathers. And that's why when 18 to 19 new parents are brought into the scheme, so people who've not presented a tax return at all for that year and therefore would have been entirely outside SEIS but for the second direction, it's not just new mothers, it's new parents.
And the significance of that is, your submission?
Well, if it had been limited to new mothers, one might have had direct discrimination against new fathers.
Begs another question.
You would have done. Yeah.
And it begs another question, which is if they could make the exception on that, why couldn't they make the exception on this?
Well, my lady,
You're going to come to that.
I'm going to
question.
come to that because it's a very different thing, we say.
Yeah.
So, my lord, I mean, those are our submissions on the first point. Can I come to point number 2, which is Fliminos? And in my submission, there are 2 reasons why the Fliminos claim should fail. And the first is that, properly analysed, Fliminos is a type of discrimination which requires relative disadvantage. So the same reasoning that I've already addressed in the context of indirect discrimination, we say applies here as well. That's the first reason. And the second reason...
So sorry, I was just finishing my notes. Give me the first reason again.
We say that Fliminos discrimination is a type of discrimination that requires relative disadvantage. So the same reasoning as I've already addressed in the context of Barry, we say applies here too.
Yes.
And the second is that in any case, in this context, we say recent mothers do not enjoy a special status that requires them to be treated differently from others who don't share it. So I'll deal with those points in turn. First of all, we say that Fliminos type discrimination, at least in a context like this, applies where a rule applied equally to all has resulted in relative disadvantage for the claimant. And it's not a freestanding duty to treat someone more favourably where you don't have relative disadvantage in the first place. And perhaps I can turn to Fliminos itself, which is tab 35 of the authorities. the Fliminos was what one might call a classic case of indirect discrimination, actually, because it was a case of the Jehovah's Witness not being appointed as a chartered accountant because he committed an offence of refusing to wear a military uniform. So in indirect discrimination terms, there was a PCP, you can't be appointed if you've committed a felony, which put him and other Jehovah's Witnesses at a relative disadvantage because they're pacifist. So it was a it was a barrier or gateway case, if I can put it that way. And one can see that from paragraph 42. I don't think I need to ask you to read the whole of that paragraph, my Lord. I just note it because I think I've made the general point. And I say it was in those circumstances that the court found at paragraph 44 that Mr. Fliminos was in a significantly different situation from persons who weren't Jehovah's Witnesses. So it was emphatically not a case where there was no difference in treatment in the first place, but the applicant was asking for more favourable treatment than others. And as far as we are aware, there is no case of the European Court applying the Fliminos principle to those circumstances without relative disadvantage.
Sorry, no case in Strasbourg in which applying Fliminos to what?
To cases where there is no relative disadvantage. And that's reflected in the analysis of Fliminos in the domestic case law too. I might turn, if I may, to a case called AM, which is tab 11 of the authorities. That's a Court of Appeal case about whether a paragraph in the immigration rules was contrary to Article 14 because it was indirectly discriminatory against the disabled. And part of the claim was a Fliminos claim. And Lord Justice Elias, in his speech between paragraphs 38 and 48, explains and applies relevant concepts of indirect discrimination and Fliminos type discrimination in Strasbourg case law.
I see. So this is actually going to take a long time for us to read now.
It will, my lord, but actually it is a very
what-
useful analysis. So
Well, we'll read it. We will, if you want, read it now. Would you like us to?
not now, my
No,
lord.
right. Where's the key passage of your
The
point?
key passage about the Fliminos claim, at least in circumstances like these, is in paragraph 45. However, as with the concept of treating like cases alike, the concept of treating different cases differently may also be the subject of a form of indirect discrimination claim. It may be argued that a rule applied equally to all, in fact, fails to have regard to a characteristic related to status, and that persons with that particular characteristic should be subject to a special rule to counter the disadvantage which that characteristic creates. The test for determining whether the applicant is adversely affected by the rule because of some such characteristic is the same as in traditional indirect discrimination claims. Fliminos itself is such a case. So that's my first submission on Fliminos. And my second submission on Fliminos, and these are alternative, I need to succeed on one of them, is that in the context of this scheme, with its particular purpose, recent mothers are not in a significantly different situation from anyone else who might have been absent from work for a whole variety of different reasons. As in my submission, there's no basis for saying, in the context of this scheme and the way it works, that a new mother who takes time off work because of maternity is in a different situation from a person who takes time off work to look after an elderly parent or a sick spouse, or someone who's themselves is old or disabled, or indeed a new father. And the answer that the claimants give to all this on special status is, well, because you're looking back to the past to work out the quantum of the claim, you need to consider whether recent mothers had a special status in the past, and they did, because that special status was conferred by EU law. And in my submission, that's not a good answer, because the circumstances in which EU law requires new mothers to be treated more favourably than others are to do with maternity pay, maternity allowance, maternity leave, and the right to return to work after a period of maternity leave has finished. And those
Indeed,
rights...
classic web and email. Sorry, I shouldn't interrupt you.
Sorry, my lord, you were about to...
Well, I was wondering, the classic web and email is about you shouldn't be dismissed because you're pregnant. Does that fit in with the point you were about to make?
It does, my lord. I'll come to that.
Sorry.
Where I say the only one of the various rights that has any relevance to the self-employed is the right to maternity allowance. And that right has nothing to do with the SEIS grant. And in fact, we say, on a proper analysis, EU law positively undermines the claimant's argument that new mothers should be treated differently in the context of calculating a SEIS grant. First of all, maternity allowance is not required to be paid at the rate of self-employed earnings. It's capped at a maximum of £151.20 a week. And it's not sex discrimination to pay the employed on maternity leave at a rate which is less than they would have earned if they'd been at work. And that's a point that my lord addressed in the Geldard case. And equally, a fortiori, it's not sex discrimination to pay the self-employed less than they would have earned if they'd been at work by way of maternity allowance. And also, the special protections for new mothers in EU law only apply during the protected period of pregnancy and maternity leave itself. Outside the protected period, new mothers don't have any special protection under EU law above and beyond that afforded to a man in the same circumstances. And that's so even when the reasons why new mothers might be disadvantaged arise from things that happen during the protected period. So, for instance, a pregnancy-related illness.
Maternity-related illness, perhaps.
Maternity-related illness.
Well,
Could also be, or either, my lord, actually.
I suppose so, yes. But the cases you're thinking of are where people mothers quite long after the birth develop something which historically is as a result of that. So that's why.
Yes.
But you're right.
Yes. It's a point that's made in Webb and Emo, albeit that Webb and Emo is, and the actual facts of that case are a bit different. But the point that's made in Webb goes back to the case that's at tab 41 of the authorities, Handels Og Forbund against Denmark. I won't attempt to pronounce the names. Which was a case where an employee returned to work, but
Yes,
then...
this is, sorry, it's normally called Hertz, this case, yeah.
Yes.
Because all Danish cases have the same name.
Yes. employee returned to work but then took further sick leave due to an illness arising as a result of pregnancy and was dismissed. And the point is paragraph 16. In the case of an illness manifesting itself after the maternity leave, there's no reason to distinguish an illness attributable to pregnancy or confinement from any other illness. Such a pathological condition is therefore covered by the general rules applicable in the event of illness. So we say that EU law doesn't support the proposition that there's a special status for new mothers, which would require them to be treated differently on the basis of the Fliminos.
Does Mr. Bunting's submission really depend on there being some special status in EU law? It simply depends on the consequences of being a new mother on your earnings.
Well, my lord, my answer to that is there are consequences on all sorts of people on earnings, whether those be any other.
I see that, but forget there's never been any EU law, and just looking at it in principle, the particular thing which has this effect is a characteristic which has long been recognised at Strasbourg as being they don't use the language of protected characteristic, but as a special status, namely motherhood. No one would suggest motherhood wasn't a status in, for the purpose of Article 14. So you don't really get off the hook by making these sophisticated but good points about EU law.
Well, my lord, I do get off the hook to this extent. What's being said is there is something different about new mothers that takes them out of the ordinary in terms of people who have taken time off for a whole plethora of other reasons. And I say, not so.
But if
now,
it
my
is
lord
said
may
to you
want to say
that
to me,
gender is
everyone
always in this context, in the context of human rights, gender or motherhood, which follows from gender, is treated differently from the ordinary vicissitudes of life.
Well, that does come back to my EU law point, my lord, because I say, yes, it is treated differently from the ordinary vicissitudes of life for certain specific purposes and in a certain period.
Okay.
But outside that, why is it different from the person who's ill?
Yeah, well, I see how you put it, and I think have you answered sufficiently the point which I'm not sure Mr. Bunting was particularly keen to make, but I think he did accept was part of it. One way of escaping the point from his point of view is to say, well, those two long-term carers might well have a special status. Everybody who just was ill for a fortnight and could prove that their earnings were fractionally less probably wouldn't have. But someone who was looking after a sick relative for a year during the reference period might well have a special status, and you might just be in just the same boat, having to defend it under justification.
Well, my lord, that's not the way it's ever been put.
No,
I appreciate that that's the way I need to address it
it's a
now.
thought experiment.
I mean, it may be that the answer is in the... If that was so, then justification would inevitably follow, because how could one possibly, in the space of 6 weeks, derive a carve-out for anyone who might be absent from work for a particular reason?
Quite.
And I suspect that was why the point was not put against us in that way, because it is absolutely obvious in my submission that once one starts thinking in that way, you think, well, how can you possibly make a scheme of this kind against the time constraints?
Yeah, no, I do understand that, but in order to see what principles are at play and what underlies the special status being said to give to mothers, it'd be interesting to see how it works for other people.
And I think the answer is that the reasons why people may need to take time off from self-employment are so multifarious, so multifaceted, that actually one cannot say that for these purposes, any of them amounts to a special status because there's nothing unique to distinguish one from the other.
Yeah.
I ought to deal in this context with the special rules for 18 to 19 due parents, because that was also something my Lady Nicola Davies raised with me. The reason why special rules were made for the 18 to 19 new parents is because without those rules, they'd have been outside the scheme altogether, because the scheme requires a tax return. Ordinarily, it requires a tax return for the 18 to 19 tax year. That's written into the rules for the scheme. And because they could be brought within the scheme by using an existing mechanism available for persons subject to the loan charge. Now, the loan charge itself, it's being suggested that sort of if special rules could be made for that, why could they not be made for this? The loan charge applied to a small number of people who were positively told by HMRC you don't have to put in an 18 to 19 tax return because you're subject to a loan charge. So put in the tax return at a later date.
Sorry, everyone else is on top of this, but I haven't quite worked out why you've got to make an adjustment for the loan charge.
Because there wasn't a tax return for which you could use your...
Because
there wasn't a tax return.
The ordinary rules of the scheme require ATP calculated on the basis of 16 to 17, 17 to 18, and 18 to 19 tax returns.
Yeah.
If you haven't been trading in 16 to 17, that can be disregarded, but you still use 17 to 18 and 18 to 19. And similarly for 17 to 18, but you always have to use the 18 to 19 tax return. The loan charge cohort was a small group of people who'd been positively told not to put in their 18 to 19 tax return at the time of SEIS 1.
Yes, I see. Thank you. I got it. Yeah.
For some reason we needn't worry about.
For some reason you needn't worry about. But they're a defined class, and HMRC knows exactly who they are, and it can use the 16 to 17 and 17 to 18 tax returns instead, which is what it did.
Why wouldn't it have been possible to disregard the tax returns for the mothers, the new mothers, in the year they gave birth?
Well, I'll take you to Max Hackon's evidence about this, my lord. It's one of the two ways that one could possibly, in theory, alter this scheme. One would be prorating, the other is disregarding years. But Mr. Hackon's evidence, which I'll take you to, explains why
we'll restrain ourselves till we get there. Yeah. Okay.
Yeah.
All right.
My lord doesn't want to, but I'm.
No, I must remember to make the point when you get back to it.
Yes.
Back to it. Just mustn't interrupt you too
Yes,
much.
looking at the clock won't help you much in this
It
problem.
doesn't.
No.
The clock is...
We've got a bit of time yet.
My lord, can I move on to justification?
Yeah.
Point 3. And I'll start with points of legal principle. And the first point is, what's the right approach of this court considering an issue of proportionality on appeal?
Yeah.
And the most recent Supreme Court authority to consider that in detail is Z against Hackney, which is tab 33 of the authorities, volume 2, where Lord Sales gives the main judgment. There's a short concurrence from Lady Justice Arden. And he set out the approach adopted by the Court of Appeal to the assessment of proportionality in the case, which he then endorsed at paragraph 56 of the judgment, which is page 995. He quotes a lengthy extract from Lord Justice Lewison's judgment. And went on to say, if one turns over the page at 66, and I'm sorry, I won't ask you to read it all now, but it would be helpful to read it, my lord.
For my benefit, has this all moved on from Re B 8 years ago, which of course I'm familiar with?
Yeah, slightly, my lord. I mean, I think that it's moved on a little bit through RR in 2018 and now in Z here.
To what, in a sentence, to what effect? To
Well,
narrow or to broaden the scope for interference with the
to slightly qualify it, perhaps. In the middle of page 996, there's a paragraph starting 66 by letter D. It's not enough simply to demonstrate an error or flaw in reasoning. It must be such as to undermine the cogency of the conclusion. Accordingly, if there's no such error or flaw, the appeal court should not make its own assessment of proportionality. And then further points, appeal court is bound to assume lower court has taken the whole of the evidence into consideration, and an appeal court should be reluctant to interfere with the lower court's findings of fact, even where those findings are based on written rather than oral evidence. And all of this is endorsed by Lord Sales, and one sees that from paragraph 74. And in my submission, that approach has real resonance here for two reasons. The first is that, for reasons I'll come on to, even if the court below did not apply the nuanced approach to margin of discretion now set out by the Supreme Court in SC, because it properly regards itself as bound by earlier authority, in practice, we say, it applied the right margin. So whether or not looked at through the prism of SC, there was some flaw in reasoning, we say it didn't undermine the cogency of the court's conclusions on justification. And the second is that the claimant's criticisms of the 5 justifications put forward by the defendant are essentially attempts to rerun arguments which were put forward to the judge and which she rejected for cogent reasons that were rooted in the evidence. So they were exactly the sort of thing that Z says should not be second-guessed. So that's the first point of legal principle. Then the second point of legal principle is, did the court err in its approach to the standard of justification required? And the answer in my submission is no. As the judge recorded, the agreed starting point between the parties was that the correct approach was MWRF, which necessarily connoted a wide margin of deference, albeit that could vary depending upon the precise circumstances. And that's what the judge applied at paragraph 69 of the judgment. And she was obliged to do so in light of DA. Of course, this is a welfare benefit case to which the ratio of DA applied in full. My lady will probably know the relevant bits of the judgment in DA so well that it's almost unnecessary for me to turn them up. But
well, no, don't do. I won't.
Page 530, my lord, of the electronic bundle. So it's the first bundle, tab 21. Well, it actually starts at 529. Paragraph 59, bottom of 528. Lord Wilson, I now accept that the weight of authority in our court mandates inquiry into the justification of the adverse effects of rules for entitlement to welfare benefits by reference to whether they are manifestly without reasonable foundation. At 65, towards the bottom of that, there was and is clear authority in Humphreys and in the bedroom tax case, that's MA, for the proposition that at any rate in relation to the government's need to justify what would otherwise be a discriminatory effect of a rule governing entitlement to welfare benefits, the sole question is whether it's manifestly without reasonable foundation. Let there be no future doubt about it. But then at 66, MWRF doesn't mean that the government gets a free pass. The phraseology of the criterion demonstrates it's something for the complainant rather than for the state to establish. But reference in this context to any burden is more theoretical than real. The court will proactively examine whether the foundation is reasonable. And it's fanciful to contemplate its concluding that although the state had failed to persuade the court it was reasonable, the claim failed because the claimant had failed to persuade the court it was manifestly unreasonable. So proactive examination. And that's exactly how the judge approached the matter. SC now makes, in my submission, 3 things clear. Perhaps we can turn that up. So tab 43. And my Lord has, my lady have read earlier bits of the judgment over lunch, but I think all I need to do is just to go to the conclusion section, which starts at paragraph 157, page 1301. I don't think you did read this bit over lunch, did you, my Lord?
We did.
We did.
did.
But never mind, you should emphasise the bits you want to
Yes.
emphasise.
First of all, paragraph 157, MWRF may still have a part to play, even in relation to differences of treatment on suspect grounds, and even outside the context of transitional measures. That's the first point. Second point, at 158, is it remains the position that a low intensity of review is generally appropriate, other things being equal, in cases concerned with judgments of social and economic policy in the field of welfare benefits and pensions, so that the judgment of the executive or legislature will generally be respected unless manifestly without reasonable foundation. Third, again at 158, that margin can be adjusted by various factors. Those factors may include the presence of a suspect ground, but I emphasise may. There's nothing automatic about it. It depends on the circumstances. And then paragraph 161, in domestic cases, rather than trying to arrive at a precise definition of the ambit of the NWRF formulation, it's more fruitful to focus on the question whether a wide margin of judgment is appropriate in the light of the circumstances of the case. But then at the bottom...
Sorry, where are we? 161?
161. But then at the bottom of the same paragraph, it follows that the ordinary approach to proportionality will accord the same margin to the decision maker as the MWRF formulation in circumstances where a particularly wide margin is appropriate. So whether or not you describe it as MWRF or as an approach to proportionality adjusted for particular factors may be immaterial. And against that statement of principle, in my submission, the basis for applying a wide margin of discretion here is particularly great. The Treasury direction, which created SEIS, it's a form of secondary legislation, I accept, not looked at by Parliament, made under the Coronavirus Act 2020. But it's also an economic and social policy measure worked up in a matter of days under huge pressure to respond to an unprecedented public health and economic emergency. And it involved enormously important macroeconomic and macro-political judgments and billions of pounds of expenditure.
How many billions?
I'm not quite sure how much it is now. It was 5.3, I think, at the time that the evidence was put in. That may be just SEIS 1. It's considerably more now. And in addition to that, the design of effective and fast social support measures that get money quickly to the right people and at the same time don't crash the economy is quintessentially an issue of policy to which there's no right answer. It's not a matter to which any established consensus applies. So, in my submission, it is difficult to imagine circumstances in which a wider margin of discretion would be appropriate. So let me turn to the three ways in which the claimants say that the judge erred. And in my submission, the judge didn't err in any of those ways when it comes to margin. The first, which is said in my learned friend's skeleton, though I don't think pressed upon you today, is that the judge had to decide what the extent of discrimination was and narrow the margin accordingly. And I say that can't take the claimants anywhere for two reasons. The first is that in this case, it's not the adverse discriminatory effects of the policy that need to be justified. It is the policy itself. It's an indirect discrimination case where what you're looking at is the justification for the policy.
I seem to remember the cases saying that's a very rigid way of looking at it. You're surely looking at the impact of the policy. You're looking both at the justification for the policy. You're looking at the justification for a policy having that degree of impact. Isn't that what the cases say? And even if it isn't that obviously right?
Yes, my lord. But
I see. So
ultimately,
what
one
point
is,
are you making there? I must have misunderstood it.
No, I mean, I'm saying that what one needs to look at, and it is important to bear this in mind, is you need to look at the justification for the policy itself and not the justification for specifically not making a carve-out from the policy for a particular group of people. Perhaps I can turn you to what's said about this in SG. That's tab 15 of the authorities.
Surely what we're looking to justify is a discrimination, isn't it? Not the policy.
You're about to show us something.
I'm about to show you
something that says something different.
Baroness Hale putting it well better than I can.
Where is SG?
SG is tab 15. And perhaps I could just ask you to read paragraph 189.
189.
189. It's fair to say that Baroness Hale was in a dissent in SG, but not on this point. So,
Yes, all right. Well, I think that is just saying what I said, isn't it? I don't quite see why it's true, but where does it get anyone?
my lord, all I wanted to do is just to correctly frame this point.
Yes, I see.
And the second point is that the judge was perfectly well aware of what was said to be the discriminatory effect here, which was that some recent mothers got paid smaller grants than they would otherwise have received if SEIS had been calculated on a basis which disregarded maternity leave. Now, she didn't accept that that effect amounted to prima facie discrimination as a matter of law, but the fact that she didn't accept the claimant's legal submissions about it, in my submission, is neither here nor there, for she was plainly aware of the effect. Indeed, she couldn't but have been aware of it, because it was at the heart of the claimant's submissions, and the effect is mentioned at numerous places in the judgment. So if one looks at core bundle page 66, paragraph 54. And equally, paragraph 62. So, I mean, really, my learned friend can't have a sort of heads I win, tails you lose approach that says unless the court's with me or prima facie discrimination, it's failed in its approach to justification. The second argument made by the claimants on margin is the alleged failure to have regard to the fact that the ground of discrimination is closely linked to sex. So that's the suspect status point. And one sees how the judge dealt with that at paragraph 70, core bundle, page 69. She recognised that the ground was related to sex, but said that didn't displace the application of the NWRF test. That was a conventional application of Humphreys. And obviously SC has now said, well, a more nuanced approach is applicable, and the dial may be shifted where discrimination is on a suspect ground. But I emphasise may be shifted, because the starting point is that even in cases where a suspect ground is engaged, and assuming that this is a suspect ground, the question whether very weighty reasons have to be shown is context sensitive. And the single point that really sings out from Law Breed's judgment in SC is that there are no universal rules which apply irrespective of circumstances. And in my submission, the judge was absolutely right in these circumstances to conclude that a wide margin was appropriate. Because the starting point is that if there's discrimination here at all, it's discrimination that arises from applying exactly the same grant calculation to all classes of self-employed person, not giving new mothers special treatment. And in my submission, it would be absurd if intense scrutiny were required, very weighty reasons were required for a universal rule of that kind in a context of social and economic policy. Well, put as a hypothetical question, why should one need to show very weighty reasons for treating new mothers in the same way as anyone else, many of whom may have had equally compelling reasons not to work a whole tax year in the past? There is in my submission no reason of principle why the law should require very weighty reasons for such treatment in relation to new mothers, but not in relation to the ill or the disabled or the old or anyone else who might have chosen to work less for reasons that are also very good. And that's so particularly when the effect of giving new mothers special treatment is to discriminate directly between them and people of other statuses who may be similarly affected.
Unless they too should have been.
Unless everyone who had a particularly good reason should have been treated in some special way. And I also say that this is quintessentially a case where the principled reason given by the European Court for requiring very weighty reasons is not engaged. And that's the reason given in SC, paragraph 103, which is stereotyping, stigma, and social exclusion. And that reasoning is not engaged at all by the ATP calculation.
And I think this plugs into the question that I asked Mr. Bunting about whether special grounds, suspect grounds, has the same weight where the discrimination is indirect.
And in my submission, my lord, no, and it can't do. I am aware, I mean, there is Strasbourg case law, and maybe that it would have been helpful to produce it to you today, except that SC came obviously very recently, and chance to give it all careful thought may not have arisen. But I think there is Strasbourg case law which has applied very weighty grounds in the context of indirect discrimination, but there's not been any principled discussion of why that should be or whether it should be.
Yes, I see. But you're saying anyway, no stereotyping, social stigma. What was your third?
No,
Social
social
exclusion.
exclusion.
Social exclusion.
The 3 and 103.
And
Which, I mean, they're all qualified by the phrase which prevent participation in society on an equal footing.
yes, and indeed, my lord, and I say none of that rubric is engaged here. And perhaps I can also turn to what Lord Justice Elias says about margin in AM at tab 11 of the authorities, paragraph 61, page 198. Because I say that has real resonance here. The court there was also being asked to require weighty reasons before disability-related discrimination could be justified.
In which paragraph are you reading from?
61.
Sorry, I do apologise for that. Thank
I'm
you.
even sir, my lord. Which case are you reading from?
It's AM, my lord. Sorry, I'm going too fast. It's
No,
tab 11.
I write my notes very slowly.
In my judgment, I categorically reject Mr. Fordham's submission that the court should require weighty reasons before this disability-related discrimination can be justified. Like Lord Justice Maurice Kay, I would accept that any rule which differentiated benefits or rights specifically by reason of disability would require weighty reasons. Prima facie, it's hard to see how it could be justified and would need to be very good reason to explain why it was being adopted. But it would be absurd to apply the same requirement to cases of indirect discrimination, particularly in circumstances where there is equality of treatment and the contention is that there should not be. The range of characteristics linked to one of the identified forms of status.
But that is my point then, in fact, isn't it? I think. Not being... That is the point, the weighty reasons, which is effectively suspect grounds, it doesn't have the same impact in an indirect discrimination.
Yes, my lord. I'm simply agreeing with you and showing you a case where precisely the same.
So weighty reasons are less important than indirect.
Yes, and also particularly where you've got equality of treatment and the contention is there shouldn't be. So particularly where it said you should create a special rule for a particular class of people.
Yeah.
Well, is there equality of treatment? You said there is because you apply the same
Yes.
APT.
Yes. Yes. So that's the second point of principle on margin. And the third point of principle on margin is the suggestion that the judge didn't have regard to the fact that justification was ex post facto. And I say that the whole premise of that argument is wrong because justification is not ex post facto. I mean, every single justificatory factor that the defendant now relies upon for the design of the scheme was addressed at the time, even notwithstanding the extreme time pressure under which the scheme was made. And if I can just briefly go through them, I mean, purpose is obvious, and because that's actually written out in the SEIS direction. The second is policy delivery, and the need for a simple design that's readily deliverable. And I said that was obviously considered at the time, because the fact that any non-automated process that required manual assessment would have affected deliverability was right at the heart of the design choices. And it's addressed at various points in the submissions, including bits of the submissions quoted in the judgment. So I can see that even from page 61, core bundle, paragraph 21 of the submissions of the 22nd of April.
I may have read this and forgotten, or it may not be there. How many persons was it anticipated this scheme would affect?
The scheme as a whole?
Yes.
About 5 million, wasn't it?
Yes, it is. It's around that.
5 million.
Yes.
Or
There
was
are
it-
around 5 million self-employed.
So an automated scheme was imperative,
Yes.
of course.
Yes.
And this grouping was in the order of 65,000.
That's the estimate, yes.
1%. Just over 1%.
So that's policy delivery. The third of the justifications is the risk of fraud. And the risk of fraud both generally and in particular fraud arising from self-certification when data wasn't available to HMRC was extensively addressed in the submissions. The risk of fraud was absolutely integral to the design choices that were made. And again, Mrs. Justice Whipple has quoted bits of that in the judgment. One sees at paragraph 25, for example, a citation to dealing with fraud. And indeed, there was specific consideration of the risk of fraud in relation to new mothers. I can perhaps just give you the page reference for that rather than turning it up, but it's supplementary bundle, page 54, paragraph 17. The fourth of the 5 justifications is perverse effects. And the anomalies that could result from adjusting the scheme for those only self-employed for part of the year were specifically addressed. And one can see that also from the judgment itself, see core bundle, page 59, paragraphs 12 to 15 of the submission of the 2nd of April 2020. And cost also considered at the time. See paragraph 17 of the same extract, core bundle, page 59. So all these justifications were considered, and the real argument is that they should have been considered in more detail or in a different way. But that is entirely different to the Brewster point. So I say the whole premise of this argument is simply wrong. My learned friend Mr. Bunting also made some suggestion that the reasons now given were not the reasons at the time, by reference to various culled extracts from the submissions. And I say two things on that. The first is it's wrong, but the second is that in any event, one's then getting into the misbehaving point. What matters is the substance of justification, not the process of reasoning. And really, in my submission, what Mr. Bunting is really trying to do under this...
Sorry, didn't be clear about this. Why is... What point... You're now addressing how I've written down as reasons, quotes, reasons different from those given at the time. How is that different from ex post facto, which is what you've just been looking at?
He's saying reasons... reasons given in addition to the reasons that the 5 justificatory factors were as it were, the real reasons, is how I understand his submission. Or he's saying other reasons are given in the papers. And I say, insofar as there are other reasons beyond the 5 justifications that we now rely upon, that is a misbehaving point. What matters is...
I see.
We consider the justifications that we now rely upon at the time, and the question for the court is, are they in substance good justifications?
Are they?
In substance,
yes.
Made out.
That's your second point. Your first point is they are really just more detailed aspects or aspects of the first point.
Yeah.
Of the 5, the 5, yes.
Before you move on, and it's been floating under what you've been speaking of in the last 5 minutes, a point I raised before the short adjournment, we can see in the document dated 22nd of April 2020, paragraph 21, for the first time there's real reference to any possibility of special rules for those caught within the maternity period. I'm not asking you, it can be done in a written document subsequently, Mr. Milford, but I'd be grateful for clarification. This is, as Mr. Bunting put it, the only reference to this detailed issue within the papers.
Well, my lady, it's not quite. I mean,
well,
so you're looking.
Don't necessarily want to take up your time now.
Yes.
A written document will do if that will make it easier.
But you were going to take us, I think, to Mr. Haycon's witness statement, and I rather assumed that if he dealt with it, that's part of what you'd be taking us to.
Yes.
And that's coming soon, is it?
It is coming soon, because my Lord will appreciate that I need to deal with justification on the facts.
Yes.
Because of what I say about Z. I mean, I say that the judge's reasoning on justification of the facts was absolutely unimpeachable. And when I do that,
Yeah,
I will
no
take
problem.
you to
But,
Mr. Haycon's witness.
On my lady's point, is my lady right in what she says? Put to you.
Well,
No, the only reference in the papers is 49.
Yeah, 49, yeah.
no, my Lord. I mean, the issue of new mothers is considered at various points, and perhaps the best place to see it is...
When you say the issue of new mothers, just so we're talking about the same thing, it's point subparagraph 3 and paragraph 18, which is answered in subparagraph 3 and paragraph 20. I think that's...
I think my lady's point is paragraph 21 on that.
It is 21. It's
And
paragraph
21.
21.
I'm sorry.
And that was the
Yes,
paragraph
that's
Mr.
right.
Bunting took us to, and I raised it then. Because that was the last document in this run of documents that he took us to.
Yes, sorry, 21.
Yes, perhaps I may have confused myself or others, but
Yes, I mean, my lady...
I understood it to be. There's two separate questions. One is that point that is dealt with there dealt with anywhere else in the contemporary documents? To which the answer is almost bound to be no, because that is the last one.
Well, it's dealt. Yes, I mean, it's dealt with in a slightly different way in the documents of the 2nd of April 2020 at page 43 and 44. That talks about that talks about the issue of pausing trade to care for a new baby and then annualising payments.
Well, we looked at those.
We looked at that. Yes, yes.
I mean,
Maria.
I really am concentrating in time
second
terms.
point.
Yes, the 22nd of April document, which gives the most detailed consideration. The point Mr. Bunting very properly made was it was no more than noting.
Yes.
And I-
Flagging up the
Indeed, my lady,
possibility.
and that's correct. So, and what I say about that is it shows a number of things. I mean, first of all, it shows it was
Well,
thought about.
Can we just
So-
cut through it?
Yes.
Is this the only, as of the 22nd of April, is that the last reference to the contemporaneous consideration of this issue?
No.
Namely, this group of women and what happens?
No, I mean, there's
Then can
also
you point us
consideration,
to it, please?
for instance, in the 5th of May document at page 53, at paragraphs 11 to 15.
Hang on 1 second.
Yeah.
So we'll need a little bit more help here. So this is described as averaging options.
And this is, yes, this it looks like we're jumping in the middle of it here. When it says where does this come from?
And you really pull it in at paragraph 13.
Yes, my lord. I mean, that's where the specific issue arises.
So this whole document is about this and another point, is it?
Yes, I mean, it's summary of option. It's all about
Reservists.
adapting size for reservists and all forms of parental leave.
Yes, I mean, we
But I'm
have to go back
slightly-
to
I'm
the
slightly-
beginning. It
Yeah.
says options for groups with periods of disrupted trade,
Yeah.
and that's effectively what the new mothers are, a subgroup of the
New mothers are a subgroup of that,
Yeah,
and
indeed that's made clear in the second line. Those with periods of maternity leave within the SEIS.
yes, and then it's also
Summary of
dealt
options,
within-
paragraph 5.
Yes, it's also dealt with in.
Mr. Bunting is desperate to say something, and I trust him enough to allow him to do so. Mr. Bunting.
I'm just conscious that chronologically it's important to note that the decision we're challenging was taken on the 30th of April.
I understand. Yes.
My learned friend
Yeah.
is taking us a document after that date.
Yeah.
At our
Yes,
invitation.
indeed.
There's nothing between whatever it was, the 22nd of April and the 30th.
There's nothing between the 22nd of April and 30th. I mean, there are no submissions between the 22nd of April
No.
and the 30th. So this issue is specifically considered in the two sets of
Effectively,
submissions.
what they were doing here was planning ahead for round 2.
Direction to
July.
Yeah.
And then, and yeah.
But it would be your submission, I imagine, that whether or not that was technically ex post facto as regards the direction under challenge, it would be highly admissible, in even although ex post facto, as showing objective reasons for the choices, or for the omission to do it first time round.
Exactly that, my lord. And indeed, if one goes to paragraph 21 on page 49, one sees at the end of that paragraph the point made that if mitigation action is decided to be taken, this will need to be achieved through the issuing of a second Treasury direction. So, you know, what's being said there is we don't have time to do anything like that now, but let's think about it and see what it is practicable and reasonable to do. And
They
Mr.
didn't
Hackon
do
then
it.
gives evidence about that.
Yeah, they didn't do it, did they?
They didn't do it, and indeed, I will take you to the bits of Mr. Hackon's evidence that explain why not.
Yes. So that was really my second point. There's two questions. One is, was this considered in the temporary documents? Answer, yes, but only afterwards, as you're now showing us.
Yeah.
Secondly, even if there are no other contemporary documents, are there further explanations in the evidence? And you
Yes.
say yes, and you're about to take us to those.
Yes.
Now? You don't have to do it now, but just so I know.
Have we finished with this 5th of May document?
We finished with it, my lord. Yes. I'm sorry, my lord. I'm just wondering whether it's best to take this out of turn and deal with it now while we're on this.
We'll let you make the
particular-
judgment, but
Yes.
there's some point to do, obvious reason to doing it
Yes.
since we're on it now.
Yeah. Well, let me take it now, because what was said below on policy delivery is that the special rules introduced in the second direction for 2018 to 2019 new parents showed that the first direction could have included special calculation rules for new mothers. And that argument, the starting point is it was addressed and rejected by the judge. See core bundle, page 70. And her conclusions were, in my submission, they were firmly grounded in the evidence. So it can't really be said that she wasn't entitled to reach them.
Which paragraph again, sorry?
Paragraph 74 to 75 of the judgment. Core bundle, page 70. And there's quite a lot said about 18 to 19 new mothers in the witness evidence, but perhaps the sort of particularly important bit is what Mr. Hackon says about it, starting at supplementary bundle, page 229. And there's a heading at the bottom of that page, the extensions to SEIS made under the second direction. There's a good example of the challenges involved in any amendment to SEIS, even a small one, is the changes that were made to include 18 to 19 parents. And then he then explains the decision to bring them into SEIS was made in late May 2020, paragraph 61. The process of making...
So sorry. Again, I've fallen behind. Which paragraph we in?
We're starting at paragraph 60, my lord, page 229 of the supplemental.
Thank you. Yep, got it now. Yep.
And paragraph 60 to 69 are all directed at a point of the point that even making a limited change for 18 to 19 parents that was essentially just about disregarding the fact that they hadn't returned a tax return for the 18 to 19 year was very complicated and took time. And could I perhaps, since we're in it, can I just ask the court to read paragraphs 61 to 69?
Perhaps you just help me on this point that concerned me. Where he refers, and the same for Ms. Cantor, to either of the claimant's proposals, I couldn't quite find where were the claimant's proposals set out. I mean, there wasn't any evidence for the claimant, so if there was, we haven't got it. I mean, there was from Ms. Chamberlain, but not evidence on this sort of matter.
Is it what the judge says at 74?
I mean, there are there were two proposals that were put forward by the claimants at various points in the case. One was prorating and the other was disregarding years. And indeed, one can see that those are the only
That's
two.
fine. I really just want to know where we found them. Are they? I haven't read.
No.
Maybe they're in the grounds. Are they?
I mean, they're... I think they're in the grounds.
Precisely. Thank you.
Yeah.
We can. Perhaps you'll
But they weren't
give
they
the
weren't
paragraph.
pressed, and indeed there's no evidence about them, and the evidence about them all comes
But
from our side.
As summarised at 74 of the judgment.
Yes,
Excluding months of maternity leave and allowing women to gross up.
yes,
Grossing up or excluding months.
yeah.
And that's what Mr. Hackon
Yes.
says
So-
would have been.
Well, he
was
deals with
far more.
prorating.
He says the 18 to 19 scheme was far simpler than either of those proposals.
Yes.
I understand that's what he's saying, and I have no difficulty understanding what in fact he's saying. And,
Yeah.
and he concludes, in fact, at paragraph 70, the sort of work that have been in the proposals would have delayed SEIS for a number of months. I've got that. But where then, going back to the contemporaneous documents, do we see that thinking?
But we see it, my lady, in exactly the bit that you looked at, which says we've got to go away and think about this.
And that-
paragraph, supplementary bundle, page 49.
Well, that's just note.
Well, these are ministerial submissions. They don't reflect the entire process.
Is it flagged up in the 5th of May document?
Yes. Yeah. They go away and think about it. It ends up with a decision to make a special rule that admits 18 to 19 parents to the scheme. But the reasons why it was not practicable to do any of the other things are addressed in detail in Mr. Hackon's evidence. And I think it might be helpful just to turn that up. So if one looks at prorating, it's supplementary bundle page 223.
We've been here before, on paragraph 32.
Actually, well, it's paragraph 34 and then 35.
Oh, I'm sorry.
There are a number of significant practical difficulties. First of all, no month-level data is held on incomes, and no data held by HMRC on periods of time away from work. You could use maternity allowance claims, but it wouldn't show how long a person had taken off from their business, or whether they went back part-time, or any other information needed to verify a claim for support on a prorated basis. Then 39, examples given above are very simple. Realities can be much more complex. Take, for example, a woman who's massively reduced her work during a maternity period but continues to work to a limited extent. How would they be treated? And then all of those create practical problems. Paragraph 41, SEIS was designed to operate on the basis of self-assessment returns data. Self-employed applicants don't submit any financial figures at all. 42 would have required a fundamentally different base design. And 44, system would have fundamentally relied not on information already available to HMRC, but on individuals' own assertions about the point at which they decided to stop working and about the reasons for that decision. So SEIS would have been left wide open to fraud. 46, in order to mitigate that risk, HMRC would have needed to put in place a mechanism whereby individuals submitted supporting evidence using verifiable data. How can you do that in the time? And 47, such a complex system would have rendered the customer journey significantly more complex. And 48, considering these issues, it has to be borne in mind that SEIS was a scheme developed over a course of weeks for millions of applications to be dealt with on an urgent basis. Wasn't and couldn't be a system that depended on complex or discretionary judgments, either from applicants or from those operating the system. It had to be simple, efficient and fast. So that's prorating. And disregarding years, dealt with at paragraph 49 and following, says that many of the same points apply to disregarding years. First of all, base design of SEIS would have had to have been different, because it wasn't designed for individuals to submit information beyond identification details in a bank account. Secondly, either you have to have self-certification about the time you've taken off, or there's a lot of work verifying and validating individual claims. Then 52 explains the loan charge. And 55 says that there's a further practical difficulty. ATP uses only 3 years of tax return data, but a disregard approach would involve some individuals either having their calculations performed on an artificial basis or falling outside SEIS entirely. And 56 applies that to the second claimant herself and indicates why, if you've got a disregard years basis, she actually gets less money than under the usual calculation.
But isn't this the explanation after the event that isn't contained in the contemporaneous documents? Look, I've just noticed this. It's page 57, tab 7. It's the follow-up advice of the 12th of June. And there's a heading parental leave, and what may be very interesting sentences have all been redacted. I know.
My lady, I don't need to show that all this detail is contained in contemporaneous documents. I need to show that the issue was considered. Yes, it was. We've seen where it was in contemporaneous documents. And I need to show that these are judgments within the expertise of the decision makers, which they are, made bona fide, which they are. So even if they were ex post facto, still worthy of full respect, see Brewster, but actually not ex post facto because one knows that it was considered at the time. That's what the documents say. I mean, otherwise you are imposing an impossibly high standard upon ministerial submissions at a time of national emergency.
I mean, what you're saying effectively is we know it was discussed at the time, subject to the point about it not being completely at the time, because it was only actually done in time for the next directive. But we know that, so the contemporary documents do show that.
Yeah.
We don't know we don't have contemporary documents showing the details of why it was rejected, but we have Mr. Hacon's evidence of why it was rejected.
We have Mr. Hacon's evidence, who was the project director with responsibility for the delivery of the scheme, and none of that evidence is controverted. I mean, the evidence is in my submission.
You would either have had to cross-examine him, or perhaps had a major, quite unprofitable, I suspect, disclosure exercise, saying we want to see all the working papers on all this. Yeah. But that wasn't done. Presumably these were produced under the duty of candour. They weren't.
No, yes, that's right. They would be used under the duty of candour.
There wasn't a formal disclosure, which is pretty standard in this sort of case.
Yes.
It's probably never been rationalised in quite the detailed or elegant language as it is in Mr. Hacon's statement to this court. But your point is that doesn't matter, because you say you can demonstrate that in outline at least, that it was all these points were considered.
Yes. Yes.
That's all you have to do.
Yes. They plainly were, and not only that, but Mr. Hacon's evidence on it makes complete sense and has never been controverted. Yeah. So the best that my learned
friend can say fallback position might. Sorry, I've interrupted you.
No, I was going to say, I mean, if the best that can be said is, well, this is not in the documents at the time, in my submission, that's not very much of an answer, because there's no attack on the substance of what Mr. Hacon is saying.
Yeah, your fallback position also could be, Brewster's not an absolute rule. Suppose actually they hadn't thought about this at all, or certainly not in any real detail, until someone asked them to do a witness statement. You've still got to say, well, is the witness statement actually a justification for not doing it, even if it wasn't thought about at the time? And that's it had to be looked at more carefully, because you can't show it was actually thought about at the time. But it doesn't necessarily mean you reject the explanation.
No,
or
certainly not.
the justification.
Yes, I mean, certainly not. And actually, it's worthwhile just turning up, Brewster, to see how this issue of ex post facto justification is addressed. So tab 16 of the authorities. Because the submission was made at paragraph 51, page 382, that where the decision maker has not made any judgment in advance of its decision about the factors which it later deploys in support of it, no institutional deference can be due to such post hoc logic, so the court has to make its own decision. Then 52, I'm not prepared to accept this submission without qualification. Obviously, if reasons are proffered in defence of a decision which were not present to the mind of the decision maker at the time it was made, brackets, not this case, this will call for greater scrutiny than would be appropriate if they could be shown to have influenced the decision maker when the particular scheme is devised. Even retrospective judgments, however, if made within the sphere of expertise of the decision maker, are worthy of respect, provided that they are made bona fide. And here you have the person who's responsible for delivery of SEIS within HMRC giving cogent reasons for his view of policy delivery and the impossibility of the two things that the claimant says should have happened. None of it is controverted, and the best that is said is, well, it's all post hoc. I say it's not post hoc, but in any event, it's within his sphere of expertise, it's not controverted, it's worthy of full respect.
Can we just pause? It's now 4:10. You've got to allow some time for Mr. Bunting, succinct though he, I'm sure, will be, indeed will have to be, to reply. We will not insist on rising at 4:30. If necessary, we'll go on a bit longer. But how much longer are you likely to be? You're nearly there, I feel.
My Lord, I think I am nearly there, because what I needed to say about justification on the facts, I've actually
We've
covered to a
forced you into saying
substantial
already,
extent
yes.
right now. Yes, exactly. So, my Lord, can I turn to justification on the facts? But I will be fairly brief about it.
Yes, I mean, just so I got this clear in my mind, you mean just up to now what you have been trying to do, although you've been knocked off course slightly, is simply showing that the judge considered it properly, and therefore we are not entitled to interfere.
Yes.
Indeed, I think it's a dividing line that is quite difficult for you to
Yes.
hold. But okay, so now you're assuming we have got to start from scratch because she got it wrong in some way.
Yes.
Yeah. Okay.
So just turning to justification on the facts, the basic answer which I give to all of these arguments is that they're reruns of points that fail below, and whether or not the approach to margin applied by the judge was correct, the cogency of her reasoning on the facts is unassailable. So I'll deal with those in turn as quickly as I can. The first is the judge's approach to purpose. The purpose of the scheme, we say, is uncontroversial. It's paragraph 2 of the coronavirus direction, to provide for payments to be made to persons carrying on a trade, the business of which has been adversely affected, etc. And for present purposes, we say the critical bit of that definition is a trade, the business of which has been adversely affected. In other words, it is designed to compensate people for the extent to which their business has been impacted. And that means establishing a baseline, which is how would the business have been doing but for coronavirus. The defendant used data on trading profits, ATP, as the best way of being able to establish that baseline. And the changes that the claimants seek involve speculating about how recent mothers' businesses would have performed but for maternity leave. So they require the use of hypothetical assumptions to correct perceived inequalities in the past, rather than the use of actual figures from actual tax returns. So whether you disregard years when recent mothers were on maternity leave or you prorate their income, in either case, you are hypothesizing about how the business would have done if the mother had not been away. You are not using actual data on how it performed.
But your prorating requires, it's not just hypothesizing, it's extrapolating from how the business had done when she wasn't on leave. So isn't that the same process in effect as ATP?
ATP uses the actual figures from tax returns, my lord. That is the difference.
Yes, but
Those are verifiable things. A hypothesis that says we are told that this particular person only worked 3 months of the year, so therefore we should multiply those 3 months' profit by 4 to reach a figure for the year, is hypothesizing. And it's hypothesizing in a context where HMRC has no data on which to verify the basic starting point, which is I was only working 3 months of the year.
If the mother produced Social Security documentation which showed that she had been taking maternity allowance for those 3 months, that would be pretty solid. If she said, well, I didn't claim maternity allowance, but I only working 50% of the time, that would be completely unsolid.
Yeah. And either of those two patterns could be right, or indeed a host of other patterns, which were...
Yes, but I suppose the point I was making is it's not as long as they stick to people who took maternity allowance.
It's not hypothesizing.
You've got a solid basis, haven't you?
It would be more solid with maternity allowance. I accept that, my lord. I don't think...
But that's not the way the case...
Yeah,
it's not clearly the way the case has been put. There's been some equivocation. Yeah.
So, and using those sort of hypothetical calculations, we say is not consistent with the purpose of SEIS grant, the SEIS grant, because what the hypothetical calculations in fact involve is saying how would the business have done but for someone being on maternity leave. And that is a different question from how has the business actually been affected. And the judge was entitled so to decide. So that's purpose. Then there's policy delivery. And the main argument made in my learned friend's skeleton is that even if it wasn't feasible to introduce special rules for recent mothers into the first round, it would have been possible to do it in next rounds. Now I can disregard that because he now says, well, I'm only challenging SEIS 1. And in my submission, the evidence is overwhelming that it would not have been possible to do this within SEIS 1. And one has that.
It's not be very good for anyone, is it? I take the point about the formal challenge. If we simply leave up in the air whether it whether it was justifiable to take the decision that was taken when they'd had a bit more time to think about it. Do you want us to decide that? Only if we decide it in your favour. No doubt Mr. Bunting will give the same answer the other way around.
No, and I'm happy to sort of take it on the chin, as it were, because actually the evidence that I've just taken to you in Mr. Hackel's statement about 18 to 19 new mothers and the difficulty of including those within the second direction, although it was a much less profound difficulty than the changes which the applicants sought, were such as to give real pause for thought, if I can put it that way.
But I'm not quite sure where that's going. Are you saying that you would be content, or positively invite us to decide whether lawful not to include special protection, whatever, not to adjust in the second direction?
Actually, my lord, I don't think I can take it that far, because the way the case was run below.
No, well, I see that. But I thought we ought to explore it.
Yeah. I mean, the way the case was run below is, well, what was done for 18 to 19 new mothers in the second direction showed that it would have been possible to make some adjustment for them
In the real world,
direction
in
that
the
we were
real
challenging.
world, we're not going to get a challenge to the second direction. One thing, they'd be out of time.
And I'm going to deal with the challenge in the way it was put, which is a challenge to first direction on the basis of what was done for 18 to
Yeah, I
mothers
understand.
afterwards.
Okay, thank you.
There've only ever been those two suggestions as to what could have been done for new mothers, which is either disregarding years or prorating. And in my submission, Mr. Hackon's evidence accepted by the judge clearly shows why neither of those would work. So that is policy delivery. The third argument is fraud risk. And what's being said here is, well, this whole scheme is wide open to fraud because it all involves self-certification by individuals that their business has been adversely affected. So, in effect, what's the problem with adding a bit more fraud to it? And that, again, was an argument that the judge considered and rejected for reasons that can't, on any basis, be said to be wrong because of any demonstrable flaw of reasoning. One sees that from paragraphs 78 to 80 of the judgment, pages 70 to 71 of the core bundle. Mr. Hackon answers this in his witness statement in terms that I accept, paragraph 22. He says
I am getting a bit concerned about time. If you're really just going to read us out paragraphs from the judgment, which we can read for ourselves, don't. You say the judge's reasoning at 71 to 80.
78 to 80. You rest your case.
78
I
to
rest
80.
my case on that.
Are you happy to do that? If there's some important point we may not have picked up, that's another matter. Okay?
Yep.
4.
Perhaps I should just let me deal with one thing that's said against me in my learned friend Skeleton about fraud risk, which is he says, well, the risk of fraud arising from special rules for recent mothers is tiny in the context of the scheme as a whole, because it's only 65,000. And I say that's the wrong comparison, because, first of all, because it assumes that a fraud risk only arises in respect of women who are actually recent mothers. And that's wrong if you prorate, for example, if you open a scheme up to people to say, I took 9 months off in a particular year, that fraud risk arises not simply in relation to the people who did take 9 months off in a particular year, or who were actually recent mothers, but in relation to any applicant for the scheme.
Okay.
And
Any woman of childbearing age could have said it, you're saying. Isn't
well,
it?
anyone could have said it.
Anyone could have said it.
And secondly, the very question at issue is whether the SEIS rules should be changed for a limited subset of people. So it's no answer to that risk of fraud in that context to say, well, the risk of fraud only arises in relation to that subset. Then there is perverse effects, and the judge's finding on that is at paragraph 81, and I say that was also firmly rooted in the evidence. If I can just give you a reference to the relevant bit of Max Hackon's witness statement. It's paragraphs 55 to 57, supplementary bundle, pages 228 to 229. And
51 to 67, did you say? 57.
55 to 57, supplementary bundle, page 228 to 229.
Yep.
And the final issue is value for money. And there, the judge's conclusions at 83 is the claimant's proposals would have cost money on IT and human intervention. And again, I say, firmly rooted in the evidence. The defendant's evidence explained exactly what the difficulties would be and why they didn't represent value for money. See paragraphs 49 to 57 of Hack-On. Supplementary bundle 227 to 229.
Sorry, paragraph numbers again.
49 to 57.
Yeah.
So, my lord, I'm sorry, I've dealt with that very quickly, and I realise that I've you've indulged me on time, but the bull point is all these issues were raised and dealt with on by the judge on a basis that can't be said to have been wrong and was indeed evidentially valid. So, my lord, unless there's something.
No? Yes, Mr. Bunting.
Can I start by answering my lord's question about the interaction of core characteristics and indirect discrimination?
Yeah.
And there's two examples which we found in the Strasbourg case law cited by Lord Reid in SC. The first is Biao against Denmark, and that's cited in SC at page
That's
1.
B-R-B-I-A-L.
B-I-A-O. Biao.
Bial, okay.
And that's cited in SC at page 1282, paragraph 108.
Yep.
And that was a case in which very weighty reasons were required to justify indirect discrimination, as Lord Reid put it.
Helpful, thank you.
Another is EB in France, which is cited in the same judgment, 1281, paragraph 107. And that was, the applicant there said she'd suffered discriminatory treatment because of a policy which related to adoption by single people, and she said that disproportionately impacted on gay people, and very weighty reasons were needed again there, paragraph 91 of the judgment.
Yes, so if Lord Justice Elias is to be read as having said something rather different in AM Somalia, he's trumped, you say.
Well, that's what he said in that case. He said it wasn't right to apply it there. There's two cases where it was applied, and here's another case which I'm about to come to, in which Lord Justice Elias, then as Mr. Justice Elias, applied this approach. And the other case is bizarrely called Elias as well.
Well, we
to add to the
well-known
panoply
case,
of Elias's. And it's a tab 7. It was an indirect race discrimination claim on the basis of a scheme that was aimed at providing compensation for returnees during World War II. And the court will see that in that case, the impact was on people based on their national origin. The Secretary of State for Defence criticised Mr. Justice Elias for applying the core characteristics approach. See paragraph 152 on page 99. And the Court of Appeal upheld Mr. Justice Elias's approach. See page 100, paragraph 160. So there are 3 cases in which indirect discrimination cases have applied that approach.
Thank you very much indeed. That's extremely helpful. Well done, I'm sure you knew all that anyway, but well done, your juniors, for reminding you.
Indirect discrimination.
Sorry, we just do the paragraph numbers 160, did you say?
Yes.
In the Elias.
In the judgment of the Court of Appeal, it's page 100, paragraph 160. The Court of Appeal upheld Mr. Justice Elias's approach in that case.
The paragraph starting, although the birth link criteria.
Let me just check that that's the right reference. Yes.
Yes, I see. Okay, thank you.
Can I turn now to indirect discrimination in general? And Barry is really the key point of discussion between us. And the problem with Mr. Milford's approach is that he skips over all the bits of Barry which emphasise the relevance of the purpose of the scheme. And the only passage he took you to was one part of Lord Hoffman's judgment. But of course, as we have seen, each of their lordships considered Barry to be a case about differential treatment, having regard to the purpose of the scheme, the purpose there being to compensate for the loss of a final salary. And even Lord Hoffman's judgment made that link to purpose. See page 44 of the authorities bundle between A and B. And the key distinction, which is the distinction noted by Mr. Justice Newberger in Silcock, was drawn by Lord Stein at page 31H to 32A of the authority. And he said there that the purpose of that scheme was that the payment was to reflect actual salary, not some notional amount calculated on types and hours of service over the whole period of employment. And the contradistinction with this case is obvious. Here we are looking at ATP as a notional amount intended to reflect past profits. And if that approach had been before Lord Stein, given the language of his judgment, it's clear that he would have found differently. Moving then to Fliminos, and the starting point here is Mr. Milford's suggestion that you must have relative disadvantage. By that, my understanding is he's trying to say because of Barry there isn't relative disadvantage, and we've already dealt with that point. And we do say that there's relative disadvantage on the facts of this case. He then goes on to say that the category of new mothers is not relevantly different to other people who also took periods of time off. And of course we say on the facts of this case that there is a category of cases recognised in law, and it's made good on the facts, that require particular protection. All of that is made clear from the wider evidence about the gender pay gap, about the way in which maternity allowance works. But it's also clear from the factual assertions made in cases like Ali and Webb. During the 3-year period that ATP is looking at, the impact and the reasons for the protected status apply. And my submission is a short one. Either the law provides protection for the reasons set out in Capital and Ali, or it doesn't. And it undermines the concept of maternity leave and its special status in law for it to be treated in the same way as all other kinds of leave.
It doesn't have special, well, it only has special status in law for those who take paternity allowance.
Well, we say that it's perhaps overstating it to say special status in law. The factual reasons given in Ali for the importance of maternity leave are what we say gives rise to a special status here.
You're sticking with the position as you made in opening, that this is about new mothers who take any form of maternity absence, however informal, whether or not they actually take maternity allowance. Is that right?
I'm sticking with this submission that this is about new mothers.
Yes.
And the reason why it disproportionately impacts on new mothers is because new mothers will have to work.
It would, I suppose, be logically possible for you to say the impact is suffered by all new mothers to a greater, or by new mothers as a class, not as by all, but
yes,
they're all at risk of it. But if the Secretary of State manages to show that with what I might call people taking informal forms of maternity absence, it's justifiable not to try to adjust for them, because how would you? You can only claim relief, so to speak, in relation to those who could prove it by having taken maternity allowance.
Yes.
Is that a way of reconciling the
Yes.
two positions?
Yes.
Lady behind him is nodding.
My point is that this is about disproportionate impact on the class, and the class which is disproportionately impacted is the class of new mothers, and how they then show that disproportionate impact will interact then with justification. And so I'm agreeing with my
Yes, it might be justifiable for some, but not for others.
Yes.
Yeah. Okay.
And so reference to the Danish case at tab 41 doesn't take us anywhere. That was obviously a case about treatment on the grounds of an illness which arose as a result of pregnancy, and that's not the same as this case. But even if my lord isn't with me on that, the impact of long-term caring, to go back to Lord Justice Baker's suggestion, does give rise to a similar point. And when that was put to my learned friend, his answer wasn't that couldn't be Fliminos discrimination. His answer was a justification point.
Just.
A justification
Yes.
point.
Yes.
So that would be more readily justifiable. And so whether it's indirect discrimination because of my reading of Barry, or whether it's clear Fliminos discrimination for those reasons, the key question in this appeal should be about justification. And I would invite the court to correct the errors that Mrs. Justice Whittle fell into, because jurisprudentially that's important for the law of discrimination, how Article 14 works. Can I turn then briefly to justification? And I agree with my learned friend. The question in terms of whether or not this court gets into the woods of the merits of the justification argument for itself will depend on whether there has been a material error of principle. And I say that there has been a material error of principle for the reasons that I set out in my opening. And realistically, Mr. Milford said, well, she may have been wrong to apply manifestly without reasonable foundation because SC hadn't yet been decided yet. But it doesn't matter because the same wide margin applies. Well, that is it with respect to material error of principle because it's substituting a new reason for the reason given by the judge. And that only arises if the court is persuaded that a wide margin, indeed the same wide margin that the judge found, is required for the reasons that Mr. Milford now gives, which are different. Can I then turn to the question of what needs to be justified? And my lord had an interesting discussion with Mr. Milford about this. And Mr. Milford answered in respect of indirect discrimination cases only. And of course, he brought our attention to SG and the comments of Lady Hale in that case. And my lord put it back to Mr. Milford, well, it's the measure in general, including its differential impact, that must be justified. And all of that's correct in terms of indirect discrimination. But the same doesn't apply in respect of Fliminos discrimination. In Fliminos, it's the failure to make an exception that has to be justified. And the references here are Fliminos itself, and it's tab 35, page 1085 of the Authorities Bundle, paragraph 44. Then it's DA in the Supreme Court, that's tab 21. See Lord Wilson at page 526, paragraph 48, and then 527, paragraphs 53 to 54. Lord Hodge and Lord Hughes agreed with Lord Wilson, page 547, paragraph 124. Lady Hale agreed on the principles, page 549, paragraph 132. Lord Kerr agreed, page 556, paragraph 162. And then it's put beyond doubt if that needs to be done by the judgment of the Supreme Court on Friday in A and B's case, and that's tab 44 in the thin volume which was handed up this morning. And the reference here is page 1354 of the Authorities Bundle, paragraph 80. So in Fliminos cases, it's the failure to make an exception that has to be justified, not the measure itself. And that may mean that Fliminos is more difficult to justify than indirect. And then that just leaves me with the facts in terms of justification. Mr. Milford says that an automated scheme was imperative. Yes, but we have seen that there were exceptions that were created that were not fully automated. The 2018-19 parents group was one such group. That approach also applied to military reservists, another group of uncertain size. And the fact that those groups were given a quantification approach that wasn't fully automated is clear from Max Hacon's statement. Indeed, the passage that Mr. Milford took you to at page 230 of the supplementary bundle at paragraph 63. And there is no explanation on the contemporaneous evidence why that approach was not applied to the wider approach, the wider category of cases in which we're looking at. Going back then to the contemporaneous evidence, the court has and has seen the 22nd of April briefing note, page 49, paragraph 21. That suggested using the disputes process as a way of partly manualising the process. And that has never been explored further in any evidence. Then the court has the post-decision briefing note that Mr. Milford took us to on the 5th of May. And the reason there, which is given for not making an exception for the category of motherhood, is given at paragraph 5b on page 52, then paragraph 11, then paragraph 16. And it is that other people, other groups, might then piggyback onto the exception that's been created for motherhood or reservist.
Free from the floodgates.
Yes, and that, of course, is not a proper way of justifying discrimination. And if authority is needed for that point, can I draw the court's attention to the judgment of this court in TP?
I think you've got to be a bit careful here. These aren't really reply points. Of course, most of them have been, but...
Well, I'm replying to Mr. Milford's reliance on the 5th of May briefing,
All right,
which
okay,
I haven't
but
taken.
we're getting to whole new authorities. It's still floodgates. What case are you saying?
TP, tab 25, paragraphs 179 to 180. The rest would really involve me addressing the court on the facts, but the court has my submissions on that, both in writing in the skeleton argument in this court and in the skeleton argument below. Unless I can assist the court with any particular points on those facts, those are my submissions in reply.
No, thank you very much indeed.
Thank you very much.
Well, you don't need to be told, but I'll say it for the benefit of the others in court. We will, of course, be reserving our judgment. We're conscious that this was listed with a degree of expedition because it's, if you're right, there are payments potentially due which people have been waiting for a long time. We will obviously deal with it as quickly as possible, but it is difficult. So I don't think you can expect a decision imminently. When we are in a position to circulate judgments, they will be sent to counsel in the usual way in draft, so that the terms of any consequential orders can be agreed, or if they can't be agreed, the parties can lodge short written submissions so that we can decide all consequential matters at the time of hand down, and also, of course, to correct any typographical or other minor factual errors. It only remains to say how well the case has been argued on both sides, and we're most grateful not only to those who actually delivered the arguments, but to those who helped to prepare them. Thank you.
Court rise.